6. Unlawful object and unlawful consideration. In terms of the provisions of Section 23 of Indian Contract Act 1872, a object or consideration of an agreement is said to be unlawful if a. It is forbidden by law. When the object or consideration of an agreement is forbidden by law, the agreement will be void. Forbidden by law means an act which is punishable under any statute as well as prohibited by special legislation, regulations made by competent authorities. B. It is of such a nature that, if permitted, it would defeat the provisions of any law. If the consideration or object of a contract is such that, if permitted, it would defeat the provisions of any law, although not forbidden by law, the agreement is void. C. It is fraudulent. An agreement, the object or consideration of which is to defraud others, is unlawful and void. D. It involves or implies injury to the other person or property of another. An agreement which involves or implies injury to the person or property of another is void. E. The court regards it as immoral or opposed to public policy. An agreement is said to be opposed to public policy when it is against the interest of public at large. The term against the public policy is highly subjective, but the following agreements are generally termed as against public policy. First, trading with enemy. A trade with a person of an enemy country against which war declared is against public policy. Contracts which are entered before the outbreak of the war are either suspended or dissolved. No contract during a war can be made without obtaining a license from Government of India. Second, stifling prosecution. An agreement to stifle prosecution tends to be an abuse of justice. Therefore, such agreement is void. An agreement not to prosecute an offender is therefore void. Third, maintenance and champerty. Maintenance is the promotion of litigation in which one person that had no interest in the litigation still gives the money to other person as assistance in the matter of the litigation. The same agreement converts into champerty when an agreement whereby one party agrees to assist the other to bring an action for recovering money or property with a view of sharing the profits of litigation. In Indian perspective, if maintenance and champerty is just to assist the other party in making a reasonable claim, such contract is valid. Fourth, interference with the course of justice. An agreement whose object is to induce any judicial officer to act prejudicially is void as it is against public policy. Fifth, trafficking public offices. An agreement for sale or transfer of public offices or to pay bribe to public servants to induce them to act corruptly is void. Sixth, marriage brokerage contract. An agreement to negotiate marriage for payment, which is known as a marriage brokerage contract, is void. Seventh, agreements tending to create interest opposed to duty. Any agreement which is creating interest against the professional duty of the person making it is void. Eighth, restricting personal duty. An agreement which unduly restricts the personal freedom of the other party is void. Ninth, agreement in restraint of marriage. As per section 26 of the Act, every agreement which wholly or partially prohibits any party from enforcing his rights under or in respect of any contract is void. 10th, agreement to commit crime. An agreement to commit any crime is opposed to public policy and is void. 11th, agreement in restraint of trade. As per section 27 of the Act, every agreement by which anyone is restrained from exercising a lawful profession, trade, or business of any kind is to that extent void. However, there are following exceptions to that section. A. An agreement not to carry on a business of which goodwill is sold is not void. A seller of goodwill of a business may be restrained from doing a similar business within a specified area so long as the buyer or any person deriving title to the goodwill from him carries on a like business therein, provided that such limits appear to the court reasonable regarding being have to the nature of the business. B. A partner shall not carry on business other than that of the firm when he agreed in the terms of dissolution under Indian Partnership Act 1932. It is not void. C. Traders and manufacturers having same line of business from associations to regulate their business in market. Their dealing is not in restraint of trade. D. It should be noted an agreement by an employer with an employee possessing specialized skill restricts him to use his skill for other person is a valid contract. 12th, agreement in restraint of legal proceedings. As per section 28 of the Act, every agreement which wholly or partially prohibits any party from enforcing his right under or in respect of any contract is void. However, any contract by which the parties agree to refer any dispute to arbitration and the award of the arbitration shall bind them is not void. Section 24. Agreements in which there is unlawful consideration and unlawful object in part, that is, partly unlawful consideration and unlawful object, and partly lawful consideration and lawful object. The following rules shall apply. First, if unlawful part can be separated from lawful part, then lawful part will be enforceable, that is, valid, and unlawful part will not be enforceable, that is, void. Second, any related or collateral transactions to the illegal transactions are also tainted with illegality, and hence total transaction becomes void. Third, in case of reciprocal promises to do things legal and also other things illegal, the second set of reciprocal promises is void agreement. Section 57.